of Coffee Talk with immigration attorney Brian D. Lerner. In this set of videos, we're talking about the good moral character element and requirement of naturalization. And there's a few recurring themes, recurring questions that come up in regards to this that I'd like to go over. Sometimes people will say they admitted to something, but they were never actually convicted. Well, for immigration purposes, a person can be denied citizenship not only if that person is convicted of the crimes, but if that person admits to the facts that constitute the crimes. So obviously, while you don't want to commit misrepresentation or fraud of being asked something, you also do not want to admit to the elements or committing the elements of the crime, because that is basically as bad as having the actual conviction itself. Now, a lot of times people will also get expunged convictions. So, they'll basically have a crime, they'll go a few years, not commit any crimes, and then the judge will basically say, good boy, you haven't done anything bad, and expunge it and dismiss it. But in actuality, for immigration purposes, an expungement does nothing for naturalization purposes because the crime, as far as they're concerned, legally exists, and the only reason you got it expunged was as a rehabilitative measure, not because you didn't commit the crime. So you want to make sure that if you're going to try to erase a crime in some manner, it's not expunged, but it's vacated, and that, of course, would have the effect of not having the crime for naturalization purposes and for good moral character purposes. Now, the Department of Homeland Security, the naturalization officer, may request all criminal records of the person applying for naturalization, but should not do so if the crime is outside the statutory period. So if you're not convicted, or if you were convicted of something prior to the 5 years, they should not request that unless, there's another caveat here, unless, number one, it's outside the statutory period, it will not result in issuing a notice to appear and would not reflect on matters that occurred within the statutory period. So it might be a little bit difficult to deny giving various arrest records and conviction records to the naturalization officer, but if you can show that it falls under those periods, then you will be able to basically deny giving those documents and not be in trouble for doing so. Now, what about probation? Now, a person on probation, parole, or a suspended sentence during the statutory period is not precluded from establishing good moral character. However, an application will not be approved until the probation, parole, or suspended sentence has been completed. So, in actuality, it doesn't make a lot of sense to apply for naturalization if your probation is still continuing. What you might want to do is make a motion in the criminal court to terminate or modify the probation so that then you can apply for naturalization. Okay, more on the coming videos.